thank you all for joining us, and thank you for sharing. My name is Madeline Kelleher, and I am here with Leslie Day to give you this presentation on kind of a recap of 2023 laws that came into place for employees and employment generally, and more on the horizon in this 2024 and even 2025. So super fun, guys. So if you have any questions, would appreciate it if you could save it till the end. And I am going to be referencing this because there are a lot of laws here that we've got going on.
Yeah. We're going to have to really cruise.
Yeah, I'm going to go as fast as I
We will be
can.
answering questions afterwards. So if you think of something, write it down, and we'd be happy to, and then in confidence be able to answer your questions.
And it's great if you write it down so that just in case we don't have any time to get to it, then we can do it via email and go through that way. Okay, so we'll start with the Illinois Paid Leave for All Workers Act, which has the effective date of January 1st, 2024. So if you guys wanted to know what the citation is, just in case you wanted to go actually look at it, I've got 820 ILCS 192. So this applies to all employers and also applies to most employees in the state of Illinois, with the exception of Federal Railroad employees, school park district employees, college or university students that work on a part-time basis for the college, short-term employees of institutions of higher education, construction, delivery, pickup, transportation, and state agency employees working under a bona fide collective bargaining agreement. So it doesn't really sound like anybody here would be like an exception to the rule. So the law now requires that employers provide employees a minimum of 40 hours of paid time off per 12-month period, and this can be used for any reason whatsoever. You can't ask for any certification or any type of documentation to prove that it was used for whatever purpose that they're telling you it was used for, if they choose to tell you, because you're not supposed to ask. So the rate for accrual would be 1 hour of paid time off for every 40 hours worked. And any exempt employees, so exempt from the overtime requirements, which we'll talk about a little bit further later on in the presentation, come join us. So they're presumed to work a 40-hour work week unless their regular work week is less than 40 hours. So then for carryover, for accrual, you have to allow carryover for unused accrued paid leave but you can cap it at 40 hours. And then front loading is permitted, and if you front load the whole 40 hours at the beginning of the 12-month period, then you do not have to require, or you're not required to allow any carryover to the next year. And then, so we'll continue with this to the Cook County Paid Leave Ordinance. So this one is effective December 31st, 2023, so the day before the Paid Leave for All Workers Act, because the Paid Leave for All Workers Act says that if any county or city or local ordinance says that, has the minimum requirements of the Illinois Paid Leave for All Workers Act and is effective before January 1st, 2024, then they get kind of grandfathered in. So Cook County decided to do theirs effective December 31st. And their enforcement of this actually began February 1st of this year. So this applies to all employers and the employees who work physically in the geographical area of Cook County. And it largely mirrors the Paid Leave for All Workers Act. So then we've got the Chicago Paid Leave and Paid Sick and Safe Leave Ordinance. It's a mouthful. This applies to all employers. And the type of employee it applies to is an employee who physically works in the geographical area of Chicago for at least 2 hours in any given 2-week period. So this can include kind of like travel time if they're traveling for business purposes and whatnot. So kind of got to be really careful to make sure you know what employees of yours actually do any business, even working from home in the city of Chicago geographical limits. So this law is going to be really fun. It's going to require employees 40 hours of paid sick leave and 40 hours of paid leave, which the paid leave would be usable for any reason per year. So this is a total of 80 hours of paid time off per year. The rate is 1 hour of paid sick leave and 1 hour of paid leave for every 35 hours worked. And we've got to allow for accrual, carryover up to 80 hours of paid sick leave and 16 hours of paid leave. So this kind of 80 hours comes into play with the Family and Medical Leave Act. So the rules are really kind of confusing. We're still waiting for another final kind of rules and explanation or guide to come out. This one's going to be effective July 1st of this year, so no need to worry about it right now, but definitely keep it in mind. The front load is permitted, of course, again, 40 hours paid sick leave and 40 hours of paid leave at the beginning of whatever 12-month period you use, whether it be the beginning of the year or the date the employee was hired or started their first day of work. And for front loading, you don't have to allow carryover of paid leave, but you are still required to allow carryover of up to 80 hours of unused paid sick leave. And again, this kind of plays in hand with the Family and Medical Leave Act. Then upon termination, employers with 50 or more employees in Chicago are required to pay out all unused accrued paid leave upon separation or even upon transfer of them working from the city limits to outside of the city limits. So that's also another one to keep in mind. So employer takeaways for all the paid leave ordinances, these three right here would be to review the laws, address any compliance gaps in your current policies or procedures, and train your HR supervisors, managers on the changes in the law. For example, not being able to ask for documentation or not requiring that be taken in any specific order because they can take it at any time. It's very interesting and very intricate. If you guys have more questions on that, please let me know. We can talk about it. Then we've got the joint employer independent contractors. So the National Labor Relations Acts, the National Labor Relations Board set forth a final joint employer rule. This is kind of in relation to Section 2 of the National Labor Relations Act. So this is effective February 26th of this year, so in a few days. Applies to all employers and all employees. So this is a federal rule. So the National Labor Relations Board's new rule provides that an independent business entity, let's call that Company A. So Company A may be deemed a joint employer of another company's employees, let's call Company 2 Company B. So Company A can be a joint employer of Company B's employees if Company A not only exerts control, like actually, controls the Company B's employees, but even if it possesses any authority to control. So this can be direct, indirect, or both, any type of authority to control. Yeah, I see some out here. It's a big change from the 2020 rules that came out, which are much less vague. So it's either possesses authority to control or actually exercises the authority to control one or more of Company B's employees' essential terms and conditions of employment. So then this new rule substantially expands to include additional terms that are in term or essential terms and conditions of employment. So definitions and conditions of employment, I'll just read it from the actual law. It includes wages, benefits, other compensation, hours of work and scheduling, the assignment of duties to be performed, the supervision of the performance of duties, work rules and directions governing the manner, means, and methods of the performance of duties and grounds for discipline, the tenure of employment, including hiring and discharge, and working conditions related to the safety and health of employees. Really broad, right? It also requires that a joint employer of a group of employees, so let's say Company A is now a joint employer, has to bargain collectively with the representative of those employees, which can be, for example, a labor union or just a representative of the employee's own choosing, maybe an attorney.
A lot of this is about unions, okay, so a lot of it's about having, if a joint employer of McDonald's, so let's say there's a franchise of McDonald's, and they want to try to unionize, right? they have to do it jointly with McDonald's. Okay, so a lot of what's going on with some of these laws are very pro-union, and to chip away at, historically, non-union type joint relationships.
Right, but it also expands to independent contractors and really, maybe
We're gonna talk
even
about that in a minute too.
temp agencies, you gotta think about that one there. So as long as
And we're
you,
gonna talk about them with the
right,
temporary labor.
so basically, so you've got to bargain over these terms and conditions of the joint employer. And then also, even if it's not defined as an essential term or condition of employment, you still have to negotiate over these terms. So the result is that it's far more likely for Company A to be deemed a joint employer of Company B's employees under the National Labor Relations Act now. So the takeaways here would be to review your current and pending contracts with third parties to evaluate whether those agreements could be interpreted as reserving the right term or condition of the other.
And you guys have staffing, temporary agencies, that's what we're talking about here.
And there's going to be some more rules on the temp agencies coming up in a minute. And then also, any employer who allows the employees of a third party to perform work on their premises should also consider reviewing the actual practices of their managers and supervisors and train them to avoid any type of actions that weren't bargained for or might be used to be argued as a direct or indirect exertion of control over the third party's entities' employees. Then we'll go next to the National Labor Relations Board's Section 7 rights, another federal law. So this was the case decided February 21st of 2023. So this was a case of McLaren-Maycomb. It applies to all employers and all employees. So in this 2023 case, the National Labor Relations Board held that agreements between employers and employees are unlawful if they restrict their employees from engaging their Section 7 rights under the Act. So if it restricts employees from engaging in any protected activity by the National Labor Relations Act, if it restricts employees from filing unfair labor practice charges with the National Labor Relations Board, helping other employees in doing so, or assisting during the National Labor Relations Board's investigatory process. So more specifically, the National Labor Relations Board held that it's an unfair practice to offer or even merely proffer the idea of giving your employees a severance agreement that contains overly broad non-disparagement and confidentiality clauses that would have a reasonable tendency to interfere with, restrain, or coerce employees to exercise or refrain from exercising their Section 7 rights. So Section 7 says that employees have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection, and also have the right to refrain, right? So what is a concerted activity? It's a legally protected class of actions when two or more workers are acting together to better their pay or working conditions. For example, if a group of employees or even just two employees are discussing their pay or are discussing their working conditions, right? So really anything that has to do with employment. Two employees are allowed to talk to each other about it. Can't restrict that.
So this is about non-union employees have protected rights by the National Labor Relations Board. So you don't want to be thinking, oh, National Labor Relations, that's just union employees.
Right.
No, this is about all the non-union employees who might decide, let's unionize. And some of the protected things they can say, perhaps while they're unionizing.
Even
they
if-
can say icky things about management. They can talk to each other about their pay. So that's kind
Right.
of what this is about, is you don't want to assume just because you're not union that you can ignore the expansion that they've done recently with rights for folks that are
Non-union.
maybe eligible to consider unionizing.
Right, but this isn't just about unionizing. This is really any employee talking to any employee about anything that's with regard to like their working conditions, pay, anything else. So just want to be clear about that. This is not like employees starting a union of their own. Okay.
Because they could, they're protected even though they didn't.
Right. So in this case also limited the non-disparagement provisions to, their verbiage is disloyal, reckless, or maliciously untrue statements. So you can't just say in your separation agreement that employee can't disparage the company. Like that is just too overbroad. It's got to be disloyal, reckless, or maliciously untrue. Takeaways here are employers offering severance agreements that contain these broad confidentiality and non-disparagement clauses. Also, for example, a confidentiality provision in your severance agreement, just want to kind of quickly mention this, that says that the employee has to keep the terms of the contract confidential. That's kind of a no-no, because that would restrict the employee from talking about their severance with another employee, right? So it's all across the board here. So those agreements that contain broad confidentiality and non-disparagement clauses, you gotta proceed in great caution. And you should also review the decision. It kind of goes over some penalties and whatnot for doing this. And then the general attorney also put out a guidance memorandum for more information on this. So next we have the new obligations for temporary employees. So this is the Illinois Day and Temporary Labor Services Act, 820 ILCS 175. This was effective August 4th of last year, but there was one portion that was delayed to April 1st, and I'll mention that again when we get to the portion of the amendments that I'm going to talk about that are the most significant portions. So this is going to apply to employers who use temporary employees and temp agencies, and also temp agencies, so it implies both the employer and the temp agency. And the day and temporary laborers are the type of employee that it applies to. So these 4 significant amendments to the Illinois Day and Temporary Labor Services Act were, first, it's the equal pay for equal work provisions. They mandate that temporary workers assigned to a third-party employer for more than 90 calendar days must be provided with benefits and payment or wages at least as much as the comparable lowest paid employee of the actual third-party employer. So let's say I'm the third-party employer. I hired a temporary labor services individual to do reception. So whatever actual employee that I have that also does reception, that is going to be the pay, like the lowest pay, and the same benefits that have to be provided to the day and temporary worker. Okay?
Same benefits.
Same benefits. So that's
Insurances, the whole.
health insurance, yeah. Yeah, the whole,
Is that provided by the staffing company or by?
that's provided by the staffing company.
Which they'll bill you the
Yeah,
equivalent
yeah.
for.
Right. So, the big,
But in the government's mind, well, then why should we use a temporary agency in the first place? Why don't I just hire them? So this is really an attack on
But if the
temporary
staffing company
staffing.
doesn't provide it, it's on them.
no.
No, okay.
It's like this really changes it so that it's really on both the employer and the staffing agency. So for example, this also is really pushing staffing agencies to also register with the state, because there's a lot of unregistered staffing agencies, and the penalties are pretty steep here. I'll get to those in a second. But so because a third-party employer who's using a staffing agency, you're actually required to make sure that they are registered and certified with the state annually before and like at all times while you're working with them. So that is where they would hold the actual employer responsible. So that 90-day calculations for the equal pay for equal work, that was delayed to April 1st, 2024, because right now there's kind of a few lawsuits saying, well, the benefits, like how do I provide equivalent benefits, because the statute is saying that you can do this in a monetary amount, but that's not, actually equivalent to the benefits that they would be getting, right? Because, I mean, just because the monetary amount, you get that, doesn't mean you're actually getting health insurance or that it's actually covering you. So we'll see what happens with that. Keep an eye out for that one.
That's a little confusing, like 90 days, like in a year? Or
Yeah.
Just 90 days ever?
90 days in a year. Yeah, not 90 days over. Yeah. Thank you for that question. So then the second significant amendment is that it mandates both the temporary agencies and third-party employers to provide the temp employees or temp workers with training specific to the job site at which they've been assigned to work. So this actually includes quite a long laundry list of to-dos with regard to training the temp worker on both sides, and providing information to the temp agency and vice versa on the training. It's kind of extensive. And then third, it gives temporary workers the right to refuse an assignment to a work site where a strike, lockout, or other labor trouble exists. Fourth, it expands the Act's private right of action by granting additional parties the ability to initiate a civil action for violation of the Act. So these penalties, like I was talking about, they're pretty steep. For the first violation, it can be between $100 and up to $18,000. Okay, this is a really big, steep penalty, depending on the violation. If you're really willfully and wantonly trying to avoid all of this, they're going to come after you, especially to make an example out of you for the first time. Okay, for any repeat violation, it's going to be between $250 to $7,500 for each repeat violation. So the takeaways here are review the law's new requirements, ensure compliance to avoid these harsh penalties, and employers using temp agencies, I talked about how that they can be liable for the failure to register and whatnot with the state. Then temp agencies should keep a close eye on that 90-day threshold and watch for the Illinois Department of Labor's permanent rules. So they have proposed rules out there, but the permanent rules are likely imminent, which will give you more guidance on how this Illinois Day and Temporary Labor Services Act is supposed to work. Also, probably a good idea to, at least if you are using a temp agency, work with them and talk to them about the law's new requirements and make sure that you look at all your contracts to make sure that they're all going to be compliant. So next we've got, where did I put that? The new bereavement leave for loss of a child. So Illinois' Child Extended Bereavement Leave Act, 820 ILCS 156. This is effective January 1st of this year, 2024. Applies to employers with 50 or more employees. The type of employee would be an employee who has worked for the employer for at least 2 weeks. The law mandates job-protected, unpaid leave for parents who experience loss of a child through suicide or homicide. And the length of leave depends on the size of the employer. So if you're an employer with 50 to 249 employees, that'll be 6 weeks unpaid leave. And then 250 or more employees, it's 12 weeks unpaid leave. This leave can be taken as a single continuous period or in intermittent intervals, but it has to be at least in increments of 4 hours. And then it must be taken within 1 year after notifying the employer of the loss. Takeaways, you need to update your leave policies and train your supervisors, managers, and HR on the new leave entitlement. Then next we have the new leave for a loss due to a violent crime. This is an amendment to the Victims Economic Security and Safety Act. So this is also Illinois. It's called VESA, V-E-S-S-A, the acronym, if anybody's ever heard about that one. So this is also effective January 1st of this year. Applies to all employees and all employers of Illinois. And so the act was amended to allow employees to take a total of not more than 2 work weeks, so 10 days, work days, of unpaid leave limited to 3 specific reasons relating to a family or household member who is killed in a crime of violence. So the 3 specific reasons would be to attend a funeral or the alternative to a funeral or a wake, to give or to make arrangements for necessitated by the death, or to grieve the death. So the leave has to be completed within 60 days after the employee receives notice or becomes aware of the death of the family member or the victim. The takeaways here again are going to be updating our leave policies in accordance with the new law and training our HR supervisors and managers on this new leave entitlement. Next we have the new leave for organ donation in Illinois. So this is the Organ Donor Leave Act, 5 ILCS 327. effective January 1st, 2024, applies to employers with 51 or more employees. And the type of employee that would be eligible for this would be a full-time employee who has worked for the employer for at least 6 months and received approval to participate in the organ donation. So the law, as amended, is that employees may use up to 10 days of paid leave in any 12-month period to serve as an organ or tissue donor. So takeaways here, again, updating our leave policies and handbooks, training HR supervisors and managers on this new leave entitlement, and then also monitoring for the new rules. The Act is requiring the Department of Public Health to adopt rules that, one, establish conditions and procedures for requesting and approving this leave, and then two, requiring medical approved by the lawyer. Those rules are going to come out hopefully soon. Next, we have the amendments to the Illinois Gender Violence Act. So this is the Illinois Gender Violence Act, 740 ILCS 82, effective January 1st of this year again. Applies to all employers and the employee. It's most employees except for some governmental positions, some vocational rehabilitation facility employees. So I don't think that really applies to anybody here, but so then all the employees would be eligible for this. So the law is that a victim of gender-related violence can sue the person who committed the act of violence to seek damages. But this can also extend to the employer if the employer fails to investigate complaints or reports of the offending conduct, to or the employee who engaged in the gender-related violence. If it's another employee who committed the crime of violence, or even it can extend to customers and third parties that like vendors that you work with. But there's a nice little caveat here. The employers who provide sexual harassment prevention training, which is required by everybody, everybody's got to do that. So the employers who provide this training have an affirmative defense that adequate training was provided to the employees. So as long as you get your sexual harassment prevention training in, and that employee attended, I'm sure all your employees attend, you should be good. Employer takeaways, updating your leave policies and handbooks, training HR, supervisors, managers, and then making sure your employees receive the appropriate sexual harassment prevention training. And this is required under Section 2-109 of the Illinois Human Rights Act. Next, we have these additional obligations to quote-unquote modernize labor notices and procedures. This came from a House Bill 3733, if you're interested. Effective January 1st, 2024. There's three main changes in kind of three various laws here applying to all of Illinois' employees. So first, employers with 100 or more employees must submit an application to obtain an Equal Pay Registration Certificate, an EPRC, by March 24th, 2024, and recertification every 2 years. So you can't any longer submit your most recent EEO-1 report to meet these EPRC requirements. It's an actual new application that you have to submit. So, and this application must include a list of all employees during the past calendar year, separated out by gender, race, and ethnicity, as reported in the business's most recently filed EEO-1. Yes, it's...
Are you allowed to ask these questions?
Yeah, that's complicated. If you have 100 employees or more, you have to ask those questions in order to complete the EEO-1, which is a mandated form. So anybody here
Right.
have 100 employees or more?
In what, like,
In a year?
Mhm.
So the EEO-1 report is mandated. You don't give people's names historically. You simply give numbers in certain job categories. Now they have made it more detailed, but
Right.
now they want not just numbers. How many white females are in the
Right.
administrative section? That's kind of how the EEO-1 does it. Now they want a list much more detailed with people's info in it. So this was an equal pay law that was passed several years ago that is now actually hitting its due date. So
Right.
if you have 100 employees or more, you need to talk to us to make sure you understand that you've gotten registered with the state.
Awesome. The second main change is a Personnel File Review Request Act going on around in Illinois. And so when an employee asks for their personnel file to review it, pursuant to the act, the employers are now provide these personnel records by email upon employee request. So not only would the employee be able to go in and review and then make copies, but you're also now required to give them a copy via email.
Does that hold for prior employees as well, or just current?
Yeah, it's going to be all employees because the act applies equally to current and post-termination employees or post-separation employees. So third main change is that all employers with employees who do not regularly report to a physical workplace must now distribute notices required by the Illinois Minimum Wage Law, the Illinois Equal Pay Act of 2003, the Illinois Wage and Payment and Collection Act, and the Illinois Child Labor Law, either by email, or some type of conspicuous posting on the employer's website or intranet site. So there's the notices that acts that the Illinois Department of Human Rights, I believe it is, or maybe it's Department of Labor, you gotta check that one, has on their website. So these all have to be sent to your remote employees or posted on your intranet site. So takeaways for this one is that you should review your policies and practices, make any required changes to compliance and managers on the new laws. Next we have just finally, even though this isn't, we'll get to the Leslie in a minute. So even though this isn't technically an employment law, we wanted to make sure that everybody was aware of the Corporate Transparency Act, which is a federal law. So this is the Corporate Transparency Act, which it's commonly known by, is actually sections 603 of the National Defense Authorization Act. So this applies to businesses with less than 21 full-time employees and less than 5 million seats or sales. November 9th, 2023, and there are 3 compliance deadlines. So if you're a new company in 2024, you have 90 days to comply. You have to fill out a report. I'll get to that in a minute. If you are already established company in 2024, you have until January 1st of 2025 to comply. But don't wait because, for example, we're working with a lot of our current clients on this, and if everybody waits the last second, we can't help everybody. Mm-hmm. So really got to make sure you're getting ahead of this because this one also has very heavy and very steep penalties. Then if you're a new company in 2025, then you have 30 days to comply and file this. The new law is that the Corporate Transparency Act has implemented that businesses file a report with the U.S. Department of Treasury's Financial Crime Enforcement, like FinCEN for short, capital F-I-N, and then capital C-E, capital C, capital E, capital N. So this was implemented to buckle down on the illegal activities such as corruption, money laundering, terrorist financing, and tax fraud. So this new report must include the full legal name and trade names of the business's address, jurisdiction of formation, taxpayer ID number or the equivalent, and here's the kicker, has to identify the business's beneficial owners and their identifying information. Kind of scary, guys. This
it extends to they have some different ways of, they have to do it separately and get on this portal and say who the owners are.
Right, so the beneficial owners, what are those? And again, it applies to all businesses with less than 21 employees, from 1 to 21. So a beneficial owner is any individual who fulfills at least one of the following. So an individual who exercises substantial control over the entity, or an individual who controls 25% or more of the ownership interest in the entity, or an individual who receives substantial economic benefits from the assets of the entity. Okay, pretty broad here. And a good example, because we're mainly an estate planning firm, that's what we're founded on here. Trustees of trusts are beneficial owners. So this identifying information includes your full legal name, your date of birth, your current residential address, and a copy of your photo ID. It's pretty extensive. And to boot, FinCEN is authorized to disclose this information to certain governmental authorities and financial institutions for select purposes. Penalties, as I said, are pretty steep. There's civil fines of $500 per day that you aren't filing your report the deadline, whichever deadline you file. And on top of this, criminal fines of up to $10,000 plus up to employer takeaways. Make sure you review the FinCEN Small Equity Compliance Guide thoroughly for your. Make sure that you file your report to FinCEN by the applicable deadline.
One time only or annually?
This is a good question. That I actually don't entirely know.
I thought it was one
I
time.
think it's one time, but
Get
for
into the
example,
big computer in the sky.
but if you have a new,
Changes, are you expected
Yes.
to file?
yes,
Okay.
right. Okay, so that's all I have for you guys for today. So thank you for listening.
Thank you.
Gotcha.
Yes. We need to switch the. I got it, thank you. All right, so we know that you have lots and lots of questions, so we want to make,
See, you gotta move in a little,
this way?
little closer, yeah.
Okay. We know that you've got lots of questions, so what we're going to do is finish up the laws that we have covered here. I am also then going to review, just quickly, a couple of prior year's laws that I want to make sure you haven't, missed or forgotten about. And then we're going to have plenty of time here for your questions. We know there's probably a lot of questions on, paid leave. Okay, it's a big one, so, please realize we're going to go through all of those. Okay, so first of all, I imagine you already know the Illinois minimum wage has gone up to $14 an hour. That includes a tip credit amount for $8.40, and if somebody's under age 18, it can go down to $12. Chicago also has a minimum wage of either $15.80 an hour for 21 employees or more, or down to $15 for smaller employees. The tip is at $9 an hour, but there's some Chicago conversations about eliminating the tip credit altogether over time, which will be really interesting for the cost of going and having a meal in Chicago, I think, in the near future. Anyway, on to the more interesting thing here is the Fair Labor Standards Act, which is what we commonly call wage and hour law. Wage and hour law allows us to have some jobs that are exempted from overtime. You commonly call those your salaried jobs, your salaried exempt jobs. For about a decade or a half, maybe 10 years ago, the minimum salary for an individual in an exempt job was like $23,000. Then there was a period of time where the Obama administration had recommended that it go up to $41,000. That got popped by a judge, so it got stopped by a judge in a case in Texas. So now the current minimum salary for somebody who's in an exempt job is $35,568 a year. Now it's going up again. Okay, so it kind of flips with each kind of administration in Washington. The proposed new amount is $55,068 per year. So the bottom line is that when this is enacted, it's just proposed at this point, you would not be able legally to have an employee in a salaried exempt job that wasn't making a minimum of that amount per year. You can include bonuses in there. Okay. The target date was April of this year. We have not seen anything positive about what's going to go on with it. There are still factions that are claiming that the government doesn't have the legal right to even do this, so we anticipate that there's going to be some lawsuits. But one thing I would suggest that you do is go back and see who all do I have as salaried exempt employees. Are they making at least $55,068?
Right, and I just wanted to point out that actually classifying your employee as exempt, it's actually a decently intricate process to understand what, requirements it falls into. If it's really got to be a supervisory role, potentially with the capabilities of hiring, firing, demoting, promoting. That is really kind of an idea of what an exempt employee would really be like. It's not just any employee who is making 55 or over, right? So got to really make sure that we properly classify, because you can then, if it's not classified properly, then they can be getting back pay for all of the overtime that they had worked throughout their entire time working for you and being classified as exempt. So that can really add up.
Right, so there's many businesses who erroneously think, oh, I'll just, pay them a salary, then I won't have to worry about overtime. I won't have to worry about a time clock or timekeeping mechanisms. So as Madeline said, there's a requirement that the person be paid on a salary, which means their pay doesn't go up and down per week or per pay period, and that it meets what's called the duties test. And one of the primary ones that Madeline mentioned was that the person supervises at least 2 full-time equivalent employees. They may also get that if they're a professional, meaning that the job requires a 4-year degree like engineering or accounting or something like that for the position, but they also can't be doing piddly stuff. Illinois has its own law in this area. It's called the 80-20 law, that says that the person can't be doing more than 20% of manual, non-exempt type work, administrative type work. Okay.
And I did want to clarify that I'm pretty sure that it's pretty positive that it's not just your salaried employees, but it's your employees who are like making wages, even if it's hourly wages, that meet that equivalent.
Right, so let's say that you have a high-paid manual mechanic, okay? Just because they're making 55, they cannot be a salaried exempt employee. They don't meet there's no criteria for being exempt that includes manual work. Exempt jobs are they call them the white-collar exemptions, so they're more for the white-collar type jobs. Professional, administrative, outside sales. Inside sales does not count. Inside sales, where you call people up and you sell, that is not an exemptable position under the rules for the Fair Labor Standards Act. In the old days, remember, people actually went out and sold? So inside sales would be like a retail environment, or somebody who was calling from their office and never going and meeting somebody in person. And there's a very small computer exemption that probably won't apply to most of you guys. So as Madeline mentioned, this is an opportunity to look and say, okay, do I have the people that are in these jobs classified right? That's the word we use for an HR. Are they classified properly as exempt or non-exempt? They can be salaried. You can pay somebody a salary, but then they would be not exempt, meaning you would still pay them overtime. So this is not the rule for salary. This is the rule for exempt. Exempt means, and they don't always go together. Salaried and exempt often go together, but they can be separate, but not to confuse you. So we don't want you to assume, one, that just because somebody's making $55,000 that now you can say, hey, you're not going to get overtime. The job has to meet these criteria. And these criteria for being exempt have been around for 30, 40 years, for a long time. Okay? So it would be very prudent for you guys to look and see everybody that you have down as salaried exempt, making $55,000 or so. If not, there's 2 things that you can do to correct that. One is you can raise the person's salary to that level and maintain, assuming that they're classified properly, maintain them as a salaried exempt employee. Or the alternative is to have them no longer be exempt. Somebody's making $45,000 and you're like, I'm not moving them up to $55,000. They would still remain as salaried, but now they would need to have a timesheet that said how many hours they worked in a week, and they would be paid for the hourly equivalent a time and a half if they work over 40 in a week. So those are the 2 general options: raise their salary up to that level, or then eliminate their exemption and have them then go down to being a salaried non-exempt employee who's eligible for overtime and that you have to document the hours that they work each week.
Right. And then there's the highly compensated employee.
That
So
doesn't apply,
employee.
no.
Oh, you got it? Okay.
That doesn't apply. That's okay.
107,432 in total annual compensation. The highly compensated employee, that it's being raised to 107,432 is what I said, I think.
Okay.
And so that's, any employee who's really compensated that much or more can fall into this exempt category.
Gotcha. Okay. Next, use of Zoom while driving. So, they don't have enough to do in Springfield, is the way I look at it sometimes. So Illinois did pass a law that has to do with distracted driving. It does not allow you to drive your car while looking at a visual, like on your phone or on your laptop, of a Zoom meeting or similar thing while you're driving.
Right, like any video conference.
Right, so you can have the video portion off and listen to the conference if you have a Zoom, but you can't be looking at a screen or having a screen up that could distract you from looking where you're driving. So it is specifically addresses anybody who's operating the motor vehicle that they cannot watch or stream a video, participate in a video conference application, which includes not limited to Zoom, Microsoft Teams, or WebEx, or access any social media site that has streaming. Okay.
The police.
The same ones that are out there looking to see if you got your hands on your cell phone while you're driving.
Right.
Yeah, so we have that hands-free driving
It's
rule.
not like there's someone sitting in the webinar that's gonna say, oh, Amber's watching while she's driving, or something like that.
Yeah.
You'd be
Now,
surprised
somebody
when that
who's not operating the vehicle can be doing it, but not the person who is operating the vehicle.
The judge on court calls will call you out for it and make you turn off your video camera.
I imagine a lot of it would be if an accident occurred and somebody alleged that you were looking at the screen, and that's what
Not
precipitated.
everybody has that.
It does say you can pull over and park and watch it. You just can't be moving. Okay. Another law that fortunately did not hit our county, Ela County, or this area, but it is required of all the counties or townships that are east of us in Lake County, requires all the employees in those areas with 50 employees or more to allow the Ventra pre-tax public transportation as a employee benefit. So if an organization east of us in Lake County, or all of Cook County, half of DuPage County, a lot of Will County, like the collar counties essentially, if they have 50 employees or more, they have to allow their employees to have pre-tax money taken out of their paycheck to use to buy a commuter benefit like a Ventra card or a train or something like that. So somebody who's east of us, and I did write down some of these counties, so Ela's not included, Cuba, Wakanda are not included, but Libertyville, Vernon Township is. Everybody that's just east of us. So that did not apply, but if you guys happen to be there, then you should begin offering that. It's very easy. It's on the Ventra a website. It has where a company can just register in. It's free to do that benefit, but the employees need to have that pre-tax ability. Okay. I do want to point out that there is a new I-9 form. I did bring a couple copies to hand out in case you have want to verify that you're using the right form. The I-9 form is the only legally mandated form in the U.S., and it's the Immigration-9 form where the employee provides you with the required documentation to show that they have the legal right to work in the U.S. It's required of every employee. You need to have an I-9 form for every employee. Okay? Now, anybody you hire as of now, you need a new form. So it's a one-page form. It used to be a two-page form where the employee would fill out their information on the first page, and then we would put the information that they provided us with documentation on the second page. Now it's all on one page. So I do have a copy of it. You want to make sure you're using the new form as of the fall last year. Okay. Yeah, okay. Okay, and I do have, let's see, one other couple other things I want to mention. Illinois passed a law that said that if you guys use independent contractors, you now need to notify the state of them, just like you would notify the state of a new hire. So your payroll company, or you may be notifying the state when you hire somebody. Your payroll company probably does it automatically for you for free if you use that service. And that stems from the fact that they were trying to find child support, parents that were not getting child support taken out of their paycheck. The state passed a law saying that if you have an independent contractor, you also need to notify the state, which I find to be quite bizarre, because I actually pulled up the reporting form you use if you're going to use a form to report that, and they haven't changed their own form yet to include that you would identify an independent contractor. So I have to say I am clueless as to how this would work.
Yeah, the state really likes to throw laws out at us and then tell us how they work months later.
So part of that would be, again, if one of these independent contractors was looking for independent contractor jobs as a way to avoid child support, now that loophole would be caught up by having them get reported to the state. So we'll have to find out what that looks like. It was effective the first of this year. I have no idea. But we wanted to let you know it's out there, and I think the reason we haven't seen a lot about it is because everybody was like, what? And if they don't even have their own website updated for this, I don't know what we're supposed to be doing. And then lastly, I just did want to mention, some of you are in industries where you do deal with OSHA. OSHA is the federal law about protecting employees' safety, right? Workers' comp is after they get hurt. OSHA is for before they get hurt. And OSHA has been drastically escalating the fines for violations. Even if there was like no cover on an electrical outlet. I'm looking for an electrical, I don't see one. Electrical out, if there wasn't a cover, that little cover plate on it, guess what?
Got it covered.
It is now $16,131.
You guys better get a cover over there. It's too open.
That looks like it's an internet thing, but just as an example, you know, here they nicely have the cord covered. Okay, that would be an OSHA violation if they didn't have the cord covered. You really want to be knowledgeable about the OSHA violations that your industry or your business might have. I think a lot of some small businesses say, oh, that's never going to happen to me. So it is, you know, there's a lot of easy ones to catch. Space heaters, they get really with some space heaters, depending on how you have offices, or have things stored up high that could fall in your copy machine room. That's where we often see that stored up high in the racking in your warehouse, things like that. You know that sign that says exit that's lit? That's an emergency exit, letting people know, let's say there's a fire, it's getting smoky, how do I get the heck out of here, right? You're going to be looking at that emergency exit. That door that's under that emergency exit cannot have a deadbolt. Okay, it has to have like a push bar where if there's a stampede of people running to get out of the building because it's on fire, they can get out. If you have anything blocking that door, it is $161,000. 161, comma 323.
Right, and these are the penalties of the state, not including any damages that you might be paying to the actual employees.
It used to be that these were like $7,000. I would say for like 2 decades, it seemed it was like $7,000. So now it is up to $16,000 for just a regular small, they call it a serious violation, and up to $161,000 for what we call a willful or something like an exit door. Exit door is the easy one that is so easy for me to catch. Also, if you're leasing your buildings from another like a landlord, it doesn't matter. You as the person who had employees working in that space one who would be compliant with OSHA. Just some big scary numbers there. Okay, looking at some of the prior laws that were out there, be important to remind you of. If you have anybody who's working 12-hour shifts or longer, as of last year, they need to have an additional 20-minute meal break. Okay. There was a law called the Crown Act that made it so you can't discriminate against somebody, perhaps very commonly in retail or something like natural hair based on perhaps belief. Okay. It's called the Crown Act. So break, locks, twists, things like that are not hiring somebody, not promoting somebody because of their hairstyle. Act, we'd like to mention to everybody, if you're not offering a 401k or a IRA for your employees' retirement funds, you need to offer a state after-tax program where you would be mandated to have all of your employees be offered the ability to. You would have to an investment fund that the state is running so that they could save for retirement since you're not offering a retirement plan. Okay, it's called the Illinois Secure Choice. It's pretty easy. The employer would get on the website, register, then they would give you the routing number and information so your employees could have any money that they wanted to invested through the state. To me, why have the state do it? Get an IRA or a 401k or something that you could manage yourself. But if you don't, you need to do that.
And that applies to employers with 5 or more employees.
Yeah, 5 or more employees as of this last year. Thank you. Okay. Madeline also mentioned the organ donor and that there also has been a law for a while that said that you needed to allow employees to take off if they were going to be giving blood. Okay.
Well,
Well,
in
guys.
Oregon, you can combine that nice policy.
I wish I knew that.
No.
There we go. Also, a law that addressed the fact that doing criminal background checks is often now going to be problematic. So does anybody here still do criminal record checks of their employees? Okay, good. Rolling right along from that. One thing I always like to point out at these seminars is even if you have one employee other than yourself, the discrimination laws in Illinois all apply. So I've often heard employees say, well, we're too small to have those laws. Illinois undid that like 2 or 3 years ago, where now if you even have one employee, you can have a discrimination allegation. Now, they've always had the law, always for a long time, maybe 20 years, they've had a law that said sexual harassment allegations could apply even if you have one employee. So you'd have to have 2 people for sexual harassment allegation, right? But now even discrimination based on race, sex, national origin, all those things could apply to a small business. So you need to listen if your employee's saying things like, that's discriminatory, or I'm being harassed, or it's a hostile. I call them the 2 H's, harass and hostile. If you hear those words, okay, you want to call Madeline, me, whatever, because those are very important words in the to do an investigation and to take steps to preclude reoccurrence of whatever was going on. Okay. Illinois passed a law a couple years ago that says that you can no longer ask applicants how much money they're making at their current or prior employers. It also says about benefits, but you just do not even want to be asking what the total compensation or whatever would be at a prior employer. So if you have an application form, you want to take that off the application form. I have a Word document, an application form that I'd be happy to just send you for free, where it allows you to have what's legally approved in Illinois for your application form. But you can't ask them, how much would you like, okay? But you can't say how much were you making at ABC Company, how much were you making at this place. You'd have to wing it, okay? And then also starting in 2025, so next year, there's a law that says that you have to, in all job postings, put a pay scale and benefits in your job postings. Now, some states already that applies. but not for another year yet. So it doesn't say a pay range, it called it a pay scale. So you may want to be starting to wonder about what you might put in your job postings for that a year from now. And that's for 15 employees or more.
Right, and there's no real rules out about like what the pay scale really means, so look out for that as well. That should be coming at some point in time,
Gotcha.
probably after the 1st of January of next year.
Okay, then also there's been a law that's been very troubling in Illinois that has to do with biometrics. So biometrics is where there's a collection of some kind of like a thumbprint or an eye scan, personal identification that is used improperly or without controls in the state. So you don't want to have a time clock where there's a hand print or a fingerprint or an eye scan. That's the common one for us in HR because that would expose you to not having managed that information properly and maybe having an incredibly troubling lawsuit regarding that.
Right. Like this has been a trend for the United States. I know California is all on top of this. There have been lawsuits where one employee can put the entire company out of business because it applies to each and every violation. So each and every time the employee uses that thumb scan or a face scan to log into whatever that they're doing, each separate time is a violation. So you want to get their kind of a waiver, a disclosure and waiver that this is happening, that the employee signs, and then also like provide them like an actual like notice or posting or something. So it's
You want to have a lawyer generate that notice. You do not want to wing it or download it from the internet.
It gets scary.
There's different states have some different requirements. So if you do have that, consider using a different kind of time clock. If you want to keep the time clock, then you would have all your employees sign these information and releases. One of your employees can say, "Nuh-uh, I'm not doing it." So many time clocks allow for that one employee to swipe like some kind of a plastic card or something like that in there as a "I don't want to play" kind of thing with that employee. But it also requires that you manage employees that terminated and delete their biometric information from the system. That's really what it's all about, that it was perceived that this information was floating around uncontrolled and it could be used in some horrible way. My fingerprint, could be used in some horrible way. So these are absolutely out of control lawsuits. Okay, so this is not something to think about if you do have anything like that or of another place that is using a biometric. Lake County actually is famous for this whole thing having kicked out over at the amusement park. That's where the first lawsuit came out of the whole thing. Okay, and then,
We're 10 minutes over.
yeah, that's it.
Yeah.
So let's see. I think that's all I have. Now, we have lots and lots of questions, so please, go. You want to stand up?
Sorry about it being past 9 p.m. It's 9:10 right now.
It says 9:30.
Trying to.
Okay, we said 9:30.
Is
We
it
said
until
9:30?
9:30? Okay,
Yeah, that's
everybody's
fine,
cool
we're
with that
fine.
then? Okay, I wasn't
If
sure
someone
about
has
that.
to leave, you're welcome to.
Okay, cool.
Hey, Brian?
Is there a class after this about selling the business?
We can help you with that too.
Yeah, it's definitely an employee's.
Yeah,
Already.
it's very
Yes.
employee friendly, the turnaround.
Yeah,
The Biden administration has put forth a lot of rules about, as we were talking about, and we're looking forward to a lot more coming within the next year. So,
Yeah, I think there was 18 laws that I addressed last year. I think we're at 12 or 14 this year. Just unbelievable quantity compared to just 5-6 years ago. I've done these seminars for so many years, and if I had 2 laws, I was like, oh my God. And so it's really hard even for us to keep track of, much less you guys know what the heck to do.
Right.
So at least this will give you the heads up as to, I think I heard about that.
So I have a question about the paid leave.
Mhm.
So we offer PTO.
okay.
Do we also have to offer this as separate PTO for the leave?
So the question will really, it depends. So a lot of employers will be grandfathered in, but as long as they meet the requirements of the 40 hours and that it can be used for any reason whatsoever without any documentation or certification. So if your policy already works with that, then fine. But if it doesn't, then you need to actually go the full measure and make sure that you implement a new policy, which we can help you with if you want.
The biggest one I see is that PTO policies often don't start on day one. So if you say, oh, you don't get any for the first 3 months or 6 months,
Or
that
year.
you would have
That
to
won't work.
have it initiate immediately upon hire.
Right.
So either that's creating an accrual sooner than you were, modifying your accrual, things like that.
Do you also have to offer carryover of this time if they don't use it all in that year? Because we don't offer carryover.
If you said you do it on an accrual method?
On accrual of
Yeah.
day of start,
Yeah, so it sounds like you might need to redo your policy then.
so we have to have all of
That
it.
Yeah.
carryover.
Or you can front load, right? 40 at the beginning, you can do it by like the beginning of the year.
Say it's unpaid. It's unpaid.
What is?
The paid time is unpaid.
No, it's not. Paid time off is paid.
If they leave, it's
Oh, so yeah, upon termination, separation.
Sometimes the carryover thing is like, well, but if they leave, you don't have to pay it. So the risk of the carryover is not as big. But then front loading it, we talked to somebody else who was front loading it, and if they leave, you don't have to pay it. So that takes some of the risk away from the carryover.
Right. The Illinois Department of Labor's proposed rules are saying that as of right now, the carryover just for accrual, but as far as upon separation, unless you have some type of bank of PTO where like the employee can store their PTO in like one bank from like multiple different policies, then you actually don't have to pay out any of the unused accrued PTO upon separation. Yeah. Any other questions?
So probably your policy says that you pay PTO at termination.
We pay pre-PTO term.
Right.
And
If
you
you
can
don't
if you'd
want
like.
to then pay this 40 hours, you would need to separate another bucket or have it be that it could be calculated separately so they could identify which one wasn't part of that. Or you're going to be paying for it at termination.
Yeah.
And all the benefits like leave of unpaid or approved time, employee needs to request it. Say they leave and they didn't request. It's not.
Okay. Right. So what notice is required for the under the Illinois Paid Leave Act to take PTO? So the act says that if it's for a known purpose, then you can require them to give you notice of not more than 5 days. So you can't ask them, you can't say it has to be 30 days before you give me notice or else you can't take it or anything like that. And then, but if it's for a purpose that was unknown, let's say like, I don't want to actually say that. I was going to say something like my mom, something, and I was like, no, I'm not going to jinx that. Let's say like, I have an emergency, okay, and I didn't know that it was going to be an emergency, then they can still use PTO for that. Like, they do not have to give you notice at all, unfortunately.
And if employee moms die and she forgot about bereavement, is it the responsibility of employer to remind her, please take it, or it's up to employee? If they didn't request, just forgot about it. Or any other benefits.
Okay, so I don't know if does anybody use like an ADP portal or something like that where anybody has to put in, or I mean, I don't know, okay, emailing that you're taking leave. So, right, like the bereavement leave and whatnot, that also can be taken like on a moment's notice. So what you would kind of want to do here is make sure that if they don't notify, like they have to notify you within the first 3 days. Like if they don't notify you in 3 days and the law says like, yeah, okay, if they're taking 3 days of leave, never told you about it, never contacted a supervisor, then they can be automatically terminated because that's not cool, right? Not showing up for work 3 days or giving your employer
No
any
call, no
reason.
show.
Right. So, but you know, if they at least notify the supervisor, then you can say, right, respond, are you going to use paid leave for this, or are you going to take no paid leave or unpaid leave. If they say paid leave, then you kind of can plug it in for them.
So it's okay for employer not to volunteer, not to nurse them.
Mhm.
You see, you approve this, take it.
They get to choose when they take it, if they take it, if they take it before any other paid time off that's offered, if they take it before bereavement leave, if they take it on bereavement leave because bereavement leave is unpaid. So it's really flexible. So, if you're using any systems where you have multiple types of PTO policies or leave policies, you should definitely require that your employee, when they're going to be taking leave, specify which leave that they're going to be taking. Because as long as they specify what leave they're going to be taking, then you can calculate it. Unless it's all in one bank, and then, as we were talking about, then we're talking about paying out unused accrued time upon separation or termination.
The other thing to think about, we're talking about that the employee didn't request it, so we're not going to pay it. Realize that what that does too is allow the employee to have another day off with that pay. So there might be something to think about. Say, well, gosh, maybe even though they didn't, specifically say I want that, nudging them may be smart, because if they have 40 hours a year that's protected under this law, and you let them take a day off unpaid, they still got those 40 hours. And those are protected. You can't fire somebody for using those. There's a retaliation protection. So why would I want to have somebody be able to take 5 days off, and then the last day, when now I'm unhappy with them, they take the leave that's protected? Maybe say, hey, remember you got paid time? Oh, right. Okay, so now there's one of those days is out of the 40. I would recommend that you consider paid time before unpaid time. That's a best practice in HR that we use, so that somebody's not having multiple days off. If they wake up and they think, do they have any money in the bank? Am I going to go into work that day? They can, at the last minute, use all of those days, and you're protected from retaliating against them, at least for 40 hours. After that, there's no protection for them.
Any more questions? We can
Mother
talk for a
Lawrence?
second just about approval or in denial of paid time off under this act, because that's a good one, real quick. So, approve, pretty much your go-to, but it says that unless there is like a super kind of strong business purpose for not allowing an employee to take paid time off at that time. Remember, they have to be allowed to take that time at least some point during the year. So all that time throughout the year. But let's say you have 2 employees from the same department, and there's only like 5 employees in that department. They both request paid time off at the same time. Then, if that department can't run with both employees not there at the same time, then you can deny one of them and then tell them, that they can choose another time to take off.
And then when they still take off, now we have a problem. So
Right.
we're still not understanding exactly how much employees can mess with us about some of this. And historically, if we said, no, I'm sorry, you can't take off, and then they still do, you have disciplinary action options. Not if they requested under this one. I would not want to be, doing that without talking to an employment attorney,
Right.
terminating them until there have been some claim suits and things like that have passed through where the state helps clarify exactly where we can say no. And
Right. Like, what
You
is
can-
a legitimate business purpose?
you can say no, and you can say you didn't give me enough time, but all that means is that you don't pay them, and they get another day off. We're learning as we start seeing some of the employee issues here that could come from that. But if you do have a legitimate department, you have to have 5 people there every day for this department and 3 people there for that department. Write those numbers down. So, because you want to be consistent in that denial. You don't want to have it that somebody who's in a protected class gets told no, but then another time somebody who didn't. You want to have it so you say, no, everybody knows we got to have 3 people there or we're going to be denying your request. Then there's not any surprises where they go, what, you just created that for me, you're discriminating against me. And aren't they saying that they're gonna come up with some more information this spring, on the law?
Yeah, right,
So who knows what that's gonna be.
right, because they're still at the proposed rules. The rules aren't final yet with the guidance on kind of like how to. Any
I
more
think our
questions?
time is up.
Yeah. Okay.
Claire, and the Chamber, we want to thank you so much for sponsoring, this seminar, and for all of you guys to get up early and come see us today. And